Good morning, and once again, welcome to Employment Hour in 30 here on Global. Your host, John Scholes. This is Lior Samfiru from the Samfiru Tumarkin law firm. And a big show today, Lior. We got all kinds of stuff to cover. If you've never caught the radio show, by the way, employmenthour.com. We do an hour radio show, have been for about four and a half years on radio all over Ontario. Go to the website to check that out. 1-855-821-5900 is the number anytime to get a hold of Lior. Lots of stuff to cover today. We'll get to the severance pay calculator. We need to talk about that. Find out exactly what your severance should be. We'll put an example up on the screen in just a little while. But first, we always start, my friend, with the week that was. What's been happening?
Well, you know, John, it's been actually a very busy week. I've been talking to so many people that have actually lost their jobs and people that have had some workplace problems. And as much as people call me with difficult situations, they invariably feel better after we speak because at least they know. At least they know what their rights are. It's always a very frustrating situation where something happens and you don't know if you have any rights. You don't know, can you do something about it? Your employer mistreated you. Do you have recourse? Is the severance offer fair? So it's not just the bad situation happening that's frustrating to people, it's the not knowing what it all means. So that's what I try to do. I try to answer those questions. What does it mean? What can I do? What are my rights? So I've been speaking with a lot of people that have heard the show and been feeling comfortable calling me and talking to me about their rights, which is terrific. I'm so happy to do that. And so if you have questions about your legal rights, if you have questions about employment law, your boss doing something, you lost your job, you're concerned about losing your job, we're going to give you our contact information so many times during this show. Give us a call. Let's talk about it. We'll have a private discussion. I can answer those questions. Don't just be there, be frustrated. Let's talk. And to get us started, John, the week that was, I'll tell you about a situation that I saw that someone called me. I'm not going to use any names or anything like that, but I think there's important lessons there for our viewers. So this involved a gentleman who was laid off temporarily. He had worked for 2 years for a company. And after 2 years, the company said, we're very slow right now, so we're going to lay you off temporarily, and we hope to call you back at some point in the next 6 months. And obviously that was it's a shock for this gentleman. He didn't want to be laid off temporarily, of course. He needed the compensation. So when he was laid off temporarily, he decided to look for another job. And sure enough, 3 months later, he found another job and he started working. Now, fast forward another month beyond that, the company, now the old company, calls him back. And they say, oh, you can come back to work. He says to them, thanks, but no thanks. I've found another job. I've moved on. Okay, and that's it. So bye-bye, farewell, and that was it. And he thought that was the end of the analysis. But he heard our show 2 weeks ago when we mentioned this issue of temporary layoffs. And he called me and he said, wait a second, Lior, am I actually owed anything from that company that laid me off some 3.5 months ago? And John, the answer was, of course, yes, absolutely. And the reason, John, why he is owed compensation is that layoff, that temporary layoff, is actually a termination. A company does not have a right to lay you off temporarily. If they do, in most cases, that becomes a termination, which means you're owed severance. So when they laid him off 3.5 months ago, even though they plan on calling him back 4, 5, 6 months later, that was a termination. So at that moment, he was owed severance. Now, he found another job some 3 months after he was let go. He was able to replace his income, but they still owe him 3 months' pay, the 3 months that he was off without any income. So I want our viewers to understand this, that if you're laid off temporarily, you have a choice. That choice is you can accept the layoff and wait at home and hope the company calls you back, or you can treat your employment as being terminated right away and get your severance. John, a company does not have a right to lay you off temporarily unless they've done it before. And if they do lay you off, that's a termination. You can get your severance and move on.
You said, yeah, if they've done it before, is there a certain amount of times they can do that and you accept it where you can no longer say, hey, you owe me severance?
Yeah.
Right?
So as I said, the company can't lay you off unless you allow them to do it before. Usually, if you've been laid off once before temporarily and you accepted it and you came back, in most cases, you're stuck. That means the company can do it again and again and again, which is why it's so important, if you are laid off temporarily, not to just accept it. You may actually be better off to leave and go and find another job rather than go back to an employer that now can lay you off temporarily whenever it wants. So if you've been laid off temporarily one time, you have to think not just about the financial aspects, do I want to get severance or not? You have to think about what this means to my future employment. You don't want to be in a situation where you come back to work for a few months, then you get laid off for a few months, and on and on and on. That's not a way to work. That's not a way to earn a living. And if that happens, you have to give me a call.
You know there's going to be viewers out there thinking, hey, wait, Lior, I've worked in construction for years. And every year I get laid off for no work.
Yeah.
How about that?
If you're working in a seasonal job, a job that's inherently seasonal, a roofer, pool cleaner, construction, then there's an implied term there that you can be laid off because that's the job. So if you are in fact laid off temporarily, then that's okay. But most jobs are not seasonal. I work in an office. If I were to lay someone off temporarily, that's a termination. I would owe them severance because it's not a seasonal job. So some jobs you may be laid off temporarily if that's the nature of the beast, that's the nature of the job. In most other jobs, no, you cannot be laid off temporarily. And if you are, that's a termination.
The website is employmenthourtv.ca and the number anytime 1-855-821-5900 to get a hold of Lior, a member of his firm. We take phone calls, of course, during the radio show all over Ontario every week. We've been doing that for about 4 years. We'll get to a call now that we had on the show recently.
My husband and I both work at the same company, and we have 2 children. I had been accommodated on daytime hours opposite his schedule for about a year and a half, and about 6 months ago, they basically said, we don't have to accommodate you. You can work any hours around your husband's schedule because you're part-time. Now I'm working overnight. It's been 6 months, but is that something that I could have thought? I didn't necessarily accept it, but I don't have a choice to work these hours.
It's a question of accommodation again.
Yeah, it's a question of accommodation. It's actually interesting how many times I get this question or variations of this question at my office. People calling me about, I need some accommodation, I need some help from my employer because I have childcare responsibilities and they won't budge, they won't change my shifts, they won't give me any flexibility, and what do I do? So let's set it straight here. An employer has a legal duty to accommodate based on what we call family status. That means if you have childcare responsibilities and the only way you can meet those responsibilities is through some help by your employer, some accommodation by your employer, the employer has to provide that accommodation. That may mean changing your hours of work, letting you start early or leave late, maybe giving you some flexibility in terms of when you come in, etc. So that accommodation has to be done. So in this particular situation, the employer can't just say, well, we don't want to do it anymore. If they do that, that's a violation of the Human Rights Code. She could potentially treat that as a constructive dismissal. She could sue or pursue her human rights damages. And beyond that, John, if the employer's already been doing this for 6 months, they've been accommodating her, they can't say, well, we can't accommodate. Clearly, you've been doing it, so it's possible to do. You can't just decide, now we've had enough. Now we don't want to accommodate you anymore. 6 months is enough. It doesn't work that way. There's no time limit on human rights, accommodation rights. So because of that, then I say if your employer won't accommodate you, try to talk to them. Make sure they understand why you need that help. But if they won't budge, give me a call. Let's talk about it. I could potentially push them into doing it. And if they still refuse, we could treat that as a termination, we could treat that as a human rights violation, and at least allow you to move somewhere else with proper compensation.
And the accommodation goes anywhere as far as families concerned, all the way to kids, or you have a sick parent, or
right.
an in-law has to be taken care of, same thing.
Same thing. Parents, children, it does apply, and it's not enough for the employer to say, or in fact, it's unacceptable for the employer to say, well, it's your family, it's your problem. It doesn't work that way. Our human rights legislation says that specifically. I recently helped a lady that needed actually to be transferred to a different plant because her son was diagnosed with diabetes, and she had to be home at a certain time to give him medication. And the company initially wouldn't relocate her. Said, too bad, you work in this plant. And even though there's a plant that's closer to your home, we're not going to move you there. Well, I sent them a letter. I explained very nicely. I can be nice sometimes. Sometimes. I explained nicely why the company had that obligation, and sure enough, they transferred the person to the other plant. So because it's the employer's obligation, they have to accommodate if there's a family reason.
EmploymentHourTV.ca and 1-855-821-5900 is the number. You can also email help@employmenthour.com anytime. You get lots of emails every week. I want to throw a basic employment scenario at you and get your comments on this. I have 5 years and 9 months of service at my company. If they fire me, how much will my severance pay be? I want to know in case they put a 24-hour deadline on their offer. Wow, that's even worse than Friday at 5.
Yeah, it is. And a lot of people do call me not because they lost their job, they just want to be prepared in case. Maybe they're feeling that something's coming down, or they're worried. They want to know, what should I be looking at for severance? So in this particular situation, the main factors, John, that go into severance is age, position, and length of employment. In this case, we only know the length of employment, 5 years and 9 months. We don't know the person's age or their job. So I'll say generally, probably looking at about 6 months' pay. Now, this person can go to severancepaycalculator.com to find out exactly. We'll talk about that more a bit later. But probably around 6 months' pay. Now, this 24-hour deadline that scenario mentioned. First of all, don't worry about deadlines. I said this before. Do not worry about deadline, whether it's 24 hours, 48, 7 days, whatever it is.
Pressure tactic.
Yeah, it's a pressure tactic. Your legal rights don't expire Friday at 5 or Tuesday at 3 or any other time. You have 2 years to pursue those rights. So when you're staring at a severance package and it has a deadline, and they all have a deadline, John, don't worry, don't panic. That deadline is meaningless. Take the time you need to understand what your rights are. Use the severance calculator. Call me. You don't like me, call another employment lawyer. That's fine. But you have to understand what you're owed. Don't worry about that pressure tactic, because if you sign it, despite the pressure, you'll realize a week later that you've lost $50,000 in extra severance that you were owed, and at that point, it's too late to do anything about it.
Do you just say kindly to your employer, you know what, thanks, but no thanks, I'm just going to take some time. I want to make some phone calls and have a look at this and take a little time to digest it before I get back to you?
Absolutely. Be courteous. Nothing wrong with saying, okay, I'm going to take the time I need. I'll be back to you in a week or 2 weeks, whatever it is that you need. And the employer can't do anything to you. I know it seems like you're being threatened, and in a way you are, but it's a threat without any power behind it, because you're owed much more in almost every situation.
And you're going to think, some people are going to think right off the top, if I don't sign right away, they're going to offer me less severance when I do come back. That is also not true.
That is not true, John. That is absolutely not true. You're owed what you're owed. So if you're owed 10 months severance and they're offering you 3, what are you concerned about? That you're going to come back and now they're going to say it's 2? Well, they owe you 10. So as long as you haven't had the opportunity to properly consider and get advice, you should not, under any circumstances, sign off on a severance package.
Again, that number, 1-855-821-5900 anytime. We'll take a short break. You mentioned the severance pay calculator. We'll run through that, give you an example, and situations in the workplace you must take action on now. That's coming up right here in the Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
You know someone that's been let go. Tell them to go to severancepaycalculator.com. You have the right to have that information. It's not what the employer wants to pay you. It's how much you're actually owed. And the place to go to, severancepaycalculator.com.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. As mentioned before, we took a break. Severancepaycalculator.com, a very simple tool. It's been around for about 4 years. You put this together, Lior. Find out exactly what your severance should be. How does it work?
Well, John, the reason I created the severance calculator, because just like in that previous scenario that we talked about before the break, people were calling me all the time, many times a day, wanting to know how much severance am I owed? Is this severance good? Or how much severance would I be owed if I lost my job? And that's such an important piece of information to have. It could literally mean tens and tens of thousands of dollars to you if you have the right information. So I created the severance calculator. It's available online at severancepaycalculator.com. And what the severance calculator does, as the name suggests, is it calculates and tells you how much severance you're owed. It's extremely easy to use. John, all you do is go to severancepaycalculator.com and you answer 3 questions: your age, your position, and the length of your employment. It's anonymous. We don't need your name. You don't need to put in any information about your company. And then you find out exactly how much you're owed, whether it's 2 weeks, 6 months, 24 months, or anything else. And once you have that information, you know you're armed, you're powerful now, because you're not going to be taken for a ride when they offer you 30 cents on the dollar, because you know what you're supposed to get. So if you lost your job, if you know anyone that lost their jobs, severancepaycalculator.com is the place to go to. It's free, it's easy to use, it takes 10 seconds, it's worth a lot.
Can we run through a quick example? Would that be cool?
So, John, let's talk about an example. This is something that actually came through my desk this week, which is why I chose it. So, this was a person that used the calculator. He was there for 14 years, the construction workers. He's 51 years old, and he was making $56,000. So, again, 14 years of service, 51 years old, construction worker making $56,000. He was offered 10 weeks' pay. And you know what, John? He actually thought it was fine.
Being
but
construction, he probably figured it wasn't owed anything.
I'm doing well here by getting 10 weeks' pay. But he heard about the severance calculator and he used it. And the severance calculator told him that he's owed 14 to 16 months pay. So he thought he was good at 10 weeks. He found out using the calculator that he's owed 14 to 16 months pay. And it even told him that the difference there in compensation is between $54,000 to $63,000. So him using the severance calculator, John, was worth to him somewhere north of $53,000. And the reason why I picked this example, it's not because this is unusual. I picked this example because it's a common one. This is exactly the type of situation that I see every single day. And so if you're watching this right now, severancepaycalculator.com, make it the first place you go to if you lost your job, and try it out. Maybe you're not worried about losing your job. It's still an important piece of information to have. severancepaycalculator.com.
We do a radio show weekly for an hour called Employment Hour. It's on radio all over Ontario. You want to find out where that is, employmenthour.com. The number to call in anytime, 1-855-821-5900. We get calls on the show all the time. Want to get to a call we had a short time. We want to play it back and get you to talk about it as well.
When they offered me the job, they also want me to sign off on a piece of paper that says, in the event that I'm ever released from the company, I agreed to restrict my severance pay to the ESA plus 2 weeks. It just seems very wrong to do that when you're at a senior leadership level. I said, what if I don't sign? And they were going to basically rescind the job offer. I did take the job. Now we're at a state where we're downsizing. What are my possibilities if they come to me and tell me my job's done?
Yeah, good call.
Good call. And so let's make it clear. Employers are starting to get wiser sometimes to this issue of severance. And one of the ways that employers can try to minimize the severance that they have to pay is with an employment agreement. They can have a term in the employment agreement that says, if we let you go, we're not going to pay you your full amounts. We're only going to pay you this other amount. So the general rule is if you sign an employment agreement that limits your entitlements, well, that's an issue. Now, as a general rule, John, if you're looking at an employment agreement and it addresses the issue of termination of employment, that's bad news. Almost always, what you would rather have is the employment agreement not say anything about termination of employment. If it says something, it only is there to limit your entitlement. So you try to negotiate with your employer. First of all, you want to understand what it says. Give me a call so I can help you understand how it limits you. Does it limit you? Should you care? But assuming we understand that it does limit you, you want to try to negotiate that with your employer. Now, if you don't negotiate or you can't and you end up accepting, here's a very important point. In many cases, we can still get out of it and around it. So I don't want anyone accepting a severance package on the basis that, wait a second, I accepted a job offer 5 years ago that limits my entitlements. I guess I'm stuck. I guess there's nothing that I can do. In many cases, we can still get out of it, get around it for reasons that I'm not going to get into right now. So it's so important. Even if you did sign an employment agreement that limits your entitlements, give me a call. In more than 50%, 60, 70% of cases, John, we can still get around it.
Well, we often said that it's contrary to what people would think. Rather than having a 15-page document, it's better to have a single pager.
Yes.
People think they're not covered. I want a big document.
Pager,
they don't.
A handshake.
Right.
Yeah, don't be worried about a handshake. Be worried about a 15-page document with a lot of words, because I promise you in that document there are going to be a ton of things that are going to be unfavorable to you. So you're right. When it comes to an employee and your employment agreement, less is more.
You know, if you want to go to terminationquestions.com, that is another website. There's you can ask a question there anytime. There's a drop-down menu. It's a good chance that your question's already been asked. If not, you can throw it out there, and within minutes it'll get answered. I want to get to one of those before we break. Again, terminationquestions.com says, I was recently terminated. They offered me 2 weeks' pay if I signed a release on any future claims to sue them. I was salaried and worked 500 overtime hours in the last year. Will signing the release prohibit me from filing a claim with the Ministry of Labor?
Okay, so
Slow down.
yeah, seriously, settle down. First of all, the worst thing you could do if you lose your job is to file a complaint with the Ministry of Labor. Okay, the worst thing that you can do, because the Ministry of Labor can only help enforce a small portion of your entitlements, and then once you file that complaint, you're stuck. You can't go back. You can't go back, and you can't pursue your full entitlement. So let's make that clear. Forget about the Ministry of Labor when it comes to losing your job. But in terms of signing a release, yes, exactly. If you sign a release, that means that you can't pursue anything, whether it's the Ministry of Labor or anything else. The release essentially says that once you've signed it, you can't change your mind, you can't go back, you can't realize that they owe you more, you've given up your rights. So we never, ever sign a release, John, unless we know we've received everything that we're owed.
We'll take a short break. When we come back, we'll get to the situations in your workplace that you must take action on. Again, employmenthourtv.ca, help at employmenthour.com through email, and the number 1-855-821-5900. Employment Hour in 30 right here on Global.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30 here on Global. Phone calls 1-855-821-5900. We do a weekly radio show. You'll want to go to employmenthour.com to find out where you can hear that show all over Ontario. We've been going for about 4.5 years. We do a lot of it, inform a lot of people. Phone calls come in all the time. Want to get to a phone call now, and you can comment it when we're done, Lior.
I have been working with a company for 10 years. My position was eliminated, and I was offered 3 months severance pay, or if I wish to apply for a new position, I had to prove myself for the next 3 months, and if I don't prove myself, then I was offered 6 months of severance pay. This is really realistic. I was a manager at this particular company. I am 55.
That is a big bowl of wrong, as we like to say.
That's a technical term here, yes. So it is, and I remember this call very well when we received it on our radio show. And what I told this lady, I assessed her as being owed 12 months severance. She's in her 50s, she's been there for 10 years, etc. So easily 12 months pay, and it could even be as high as 14 months pay. They've offered her either 3 or 6 months, depending on this other position. Either way, John, that's pennies on the dollar, anywhere from 30 to 50 cents on the dollar. So it's nonsense. It's completely ridiculous. And they almost make it seem to her like it's a good offer. So that offer is completely inadequate. She certainly doesn't have to apply to a different job within the company. If she has a job, if the company doesn't want her to work in that job, they can let her go. And they can't try to pay her 30 cents on the dollar. So that's a wrongful dismissal. A lot of people confuse this term wrongful dismissal in terms of what it means. A wrongful dismissal simply is a situation where you're let go and you're not offered the severance that you're owed. So she's been wrongfully dismissed, and I had spoken to her and I told her that exactly, and I'm helping her right now as we speak to get the severance that she's owed.
And I noticed that she slipped into that phone call as well. They offered her a different position, but they wanted to put her back on probation.
Yeah.
She's been there for 10 years.
How ridiculous is that? So we're going to try you out. We're going to take you for a spin here after you've worked for us for 10 years. You can't really be put on probation once you've already worked there for a while. It's just nonsense. I think, with respect, that's probably a company that doesn't really know what it's doing. So the good news is we'll be able to resolve this pretty quickly.
EmploymentHourTV.ca, 1-855-821-5900. You want to email Lior or the rest of the firm, it is help at employmenthour.com as well. We mentioned this segment. Want to get to this now. Times, things in the workplace you have to do something about if they arise. Number one, your employer is building a case against you. You should recognize that.
Yeah, absolutely right. And when does your employer build a case against you? Your employer is building a case against you when nothing you can do is right all of a sudden. Everything was fine, and all of a sudden now everything you do gets scrutinized, you get penalized, you get written up, there's a bad performance review, and all these things in writing are happening. That means your employer is building a case to potentially push you out, to let you go for cause. And for cause means no severance. Now, it's very difficult to terminate for cause. So just because your employer is trying doesn't mean that they're able to. But if you know your employer is building a case, don't make it easy on them. Build your own case. So keep records of things that justify or support your position. If you disagree with something that the company says that you've done, say it.
Document it.
Document and say it in writing. Send an email. You've told me that you said that I did this. I didn't. Here's what actually happened. So the problem with being silent is silence is the same as acceptance. So if you've accepted something, it's going to be very difficult later on to say this was wrong and that was wrong. Well, if it was wrong, say so. So if your employer is building a case against you, build your own case, make it even more difficult for your employer to let you go for cause. And of course, if you are let go for cause, I'll put that as the number one time to call me. You really have to.
Again, 1-855-821-5900 is the number, talking about situations in your workplace where you've got to do something about it right away. We talked about this earlier in the first segment. That is, you're offered a new employment agreement when you're already working.
Yeah,
You're already
exactly.
there.
And man, that's always bad. You will never, ever be offered an employment agreement when you're working that gives you a better deal.
Of course.
That makes it better for you than what it was. And even if it appears on its face to be better, look, John, it gives you another 50 cents an hour. Okay, that's 50 cents, that's okay. But there's going to be terms in that agreement that take away a lot more than 50 cents. Potentially a termination clause, something that limits your future severance. So if your employer comes to you out of the blue and says, now I want you to sign a new employment agreement, be worried, be very concerned. Let's talk, let's make sure that we understand what it is. And in most cases, the answer is going to be, or should be, no, I'm not going to sign it because I'm not going to give up on my rights. And guess what, John? Your employer cannot make you sign an employment agreement.
Wow. A couple scenarios. If you get that agreement and you say, okay, you know what, I am going to sign it, can you just sign it and walk away and have it stick, or do they have to offer you something? Can you say no?
So generally speaking, you can always say no, even if they offer you something. Right. But if they don't even offer you something and you still sign it, it's probably not even enforceable. Wow. But if they say, here's John, we're going to offer you a 50 cents an hour or 50 cents an hour pay increase, and you sign it, it is enforceable, but you still should not sign it, certainly not without reviewing it, because there could be terms in there that are going to cost you a lot more than that 50 cents an hour raise.
Situations in your workplace where you got to do something about it, you got to call Lior, member of the firm. This one it's in the news every day. Every hour we hear something else, and that is harassment in the workplace.
My gosh, yeah, you absolutely have to, because if you don't, if you're being harassed, it's going to impact you in many ways that are not even related to the workplace. It's going to impact your health, your well-being, your family, and it's just a really bad situation to be in, and it's a bad environment if you're being harassed at work. And the reason why I say you have to do something is the law is actually so good in protecting employees from harassment. So as a starting point, talk to your boss, talk to the HR person, make sure that they know what's happening, and give them the opportunity to fix the problem. They have to investigate, and they have to do whatever they can to eliminate the harassment. If you've done that, or if it's impossible to do it.
If it's the boss.
If it's the boss, if it's the HR manager, it's the owner. So if you can't approach the company, or if you've approached them and it hasn't helped, then you call me. Then we deal with it externally. There's legal remedies, there's a constructive dismissal, human rights. You should never, ever suffer harassment. The law is really good when it comes to protecting, getting you out of there, getting you compensation, allowing you to move on. So if you're in that situation, try to deal with it. And if you can't, you just give me a call.
Your boss or your employer changes the terms of your employment, that's another red flag you got to do something about.
It's a huge red flag. So we're talking about pay decreases, relocation, demotions. The problem with not doing something, John, if you've been experiencing changes to the terms of employment, is by not doing something, it's as if you're saying, yes, that's fine, I accept it, I'm good with it. And if you're good with it, you're giving them the right to do it again. So maybe now it's a 10% pay decrease, but if you're good with it and you accept it, then it could be another 10% and another 10% and another. And at that point, you can't do anything about it. So if you're going to have changes to the terms of your employment happening, you give me a call, because we may have to treat that as a constructive dismissal. We may want to get you out of there. And if that's what happens, that's much better than being in a situation where bad things happen again and again and again.
Last one before we wrap, accommodation. They won't accommodate you in the workplace.
We touched on that earlier, John. If your employer won't accommodate you, maybe you have a medical condition, you need some help. Maybe you have a family situation and you need help with that. Well, if your employer won't do that, that's wrong. That's a human rights violation. So you should talk to them, give them an opportunity to fix it, or you give me a call. You don't want to accept that. You don't want to just be there and say, well, too bad, because they have to. So especially when it comes to a medical condition, you don't want to hurt yourself because the company won't accommodate you. So you call me, let's talk about that. And if we can't get them to change and to accommodate you, at least we can get you out of there with compensation.
Another great week, my friend. If you caught this one, you want contact as we close, 1-855-821-5900 is the phone number. It is help@employmenthour.com. And to see past shows and get more information, employmenthourtv.ca. Till next time, Employment Hour in 30, right here on Global.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
You know someone that's been let go. Tell them to go to severancepaycalculator.com. You have the right to have that information. It's not what the employer wants to pay you. It's how much you're actually owed. And the place to go to, severancepaycalculator.com.